Children are supposed to be having a childhood. In childhood, there is no place for marriage. These were the words of Renuka Chaudhary, the Minister of State for Ministry of Women and Child Development at the time, and these were her words on 19th December 2006 while she was advocating for a revolutionary law called the Prohibition of Child Marriage Act. The bill, of course, became a law a few days down the line. In fact, the same day that she uttered these words on 19th December 2006 was when the bill was passed in the Lok Sabha, and it provided for quite a few provisions. Instead of preventing child marriage, focused on prohibition of child marriages. It provided for higher punishments for those abetting, supporting or solemnizing those marriages. And this is the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra. Sinha. You've seen us for all the episodes of this show. And we have with us Supreme Court lawyer Bansuri Swaraj. Thank you so much for joining us, Bansuri.
My pleasure. Thank you so much, Bansuri. So, as Apoorva pointed out, this law was introduced in 2006. But before that, prior to this, we already had a law in place. That is the Child Marriage Restraint Act, which goes back to 1929. Yes. Then some modifications were made in it regarding the age of marriage. So, how is this law different from the preceding law?
So, Bhadra, as you know, the problem of child marriage was always seen as a social evil.
Right.
But what happens is that child marriage has far-reaching repercussions. I mean, just see, it actually has an impact on not just infant mortality rate, on maternal mortality rate. It also has an impact on the female labor force in the workplace. It has repercussions on nutrition. It has repercussion on gender equality, etc. Now, as you said, that there was already a law pre-independence in 1929, but that time the age of marriage was 14 years. Now, of course, 14 years, as you know, this is a very archaic concept. You basically needed to have something which was more up to speed, and therefore the 1929 Act was amended in 1978, where it said that for a girl, the age of marriage had to be above 18 years, and for boys, it had to be 21. The 2006 Act maintained the minimum age of 18 years for women and 21 years for men. But of course, it definitely had far more provisions. It had provisions where a child, upon attaining maturity within 2 years, so up to the age of 20 years of age, could file a petition and then ask for annulment of the marriage.
Okay.
Any party who was a minor contracting party, it could be the groom or it could be the bride. Similarly, the Act also facilitated punishment for those who were solemnizing the marriage. But what I'm very pleased to say that now we are talking about the 2021 bill, which actually brings it sort of widens the scope. One, it talks about, and it has already been tabled in the Lok Sabha, it has been now referred to the standing committee. It talks about raising the age for both men and women to the age of 21 years. And it talks about how, for the fact that earlier where you could move the petition for annulling the marriage only up to 2 years after attaining maturity, which is 20 years, now it broadens that to 5 years. So a child who has attained maturity can go ahead and request for annulment right up to 23 years of age.
But we'll talk about the new bill a little bit later. I mean, talk about the controversy that it raised. Apart from this, did this particular law for the first time introduce the concept of child marriage prohibition officers as well?
Yes.
And what is the role assigned to these prohibition officers?
Now, child marriage prohibition officers are ones, they have threefold. They need to prevent the marriage, they need to prosecute, as well as they need to do awareness. And I think awareness is the majority of their work. And I have to say that the 2006 law has actually brought down the percentage in India. It's not a very encouraging statistic, but it is still at 23%. Okay. So that kind of decline has happened because of this law that has come in 2006.
So can we call this law, is it like criminal in nature?
It is criminal in nature because it does have punitive measures. It does, of course, allow for imprisonment up to 2 years, as well as and or fine, and in certain cases imprisonment as well as fine. But personally, I feel that perhaps 2 years is too less. Okay. We do need far more stringent punishments. What happens is that the Prohibition of Child Marriage Act relies a lot and very heavily on the POCSO Act to punish. So it is criminal in nature, but it does need a lot of, support from, I would say, the POCSO Act.
Totally specialized.
It is a special law in which the same offense is punishable. Basically, if you have a sexual intercourse with a minor who is less than 16 years of age, then it's punishable up to 20 years.
And can the police register a suo motu case against this law, or do we specifically need a complainant? And can anybody be a complainant? In the sense, somebody who witnesses the marriage or who attends the marriage, can anybody go to the police station and complain?
Absolutely. Anybody can, because this is a social evil. This is a crime against society. Anybody can go ahead and register the complaint, as well as suo motu action can be taken by the police.
When you started with the introduction to the law, you said that it is treated as a social evil. What I want to ask you is that does this law change that aspect, in the sense, now do we see a child marriage as a crime? Does it still continue to be a social evil or a crime?
It ought to be a crime. It definitely needs to be a crime. I think we need to look a little bit about the history of it. First of all, child marriage is not peculiar just to India. This is a problem which is universal in nature, and that is why, as you know, there are many conventions by the UN and the United Nations keeps on coming up with guidelines. But in India, what happens is marriage was always seen as an alliance, as a socio-economic alliance between families. So child marriage came into existence because you wanted to make families powerful at the earliest possible. So you had children as young as 3 years old being married off, because you saw it as a socio-economic alliance between two powerful households coming together. Another reason is that we've had a very difficult past. We are a country that was invaded very, very regularly. So there was a very skewed sense of trying to protect our women by marrying them off early. These are all archaic concepts. These are redundant concepts. In today's age and date, child marriage stunts the growth of children. It obstructs their development. And that is why we were talking about the bill. Yeah. 21 years of age will ensure that children, both a girl and a boy, have not only completed their schooling, which is basic education, but would have also completed their college and hopefully would be in their first year of a job.
Okay.
So do you think the 2006 law sort of tried to tackle the social evil of child marriages from all sides, maybe socially as well, by bringing in awareness as well as making it a crime, a more wholesome approach?
Absolutely, Apoorva, absolutely. Because when we are dealing with a social evil and it is so deep-rooted in society, awareness is the first step. You have to tell people that this is wrong, correct? Especially if something is rooted in tradition. Right. You need to tell them why the tradition is archaic, why this is a crime, but you need to have a holistic approach. You need to have a deterrent of having a punitive measure there.
But there is a line of argument that there is in fact a lacuna in the law, yes, and which actually deals with the aspect of whether this marriage, a child marriage, is void or not, or whether it is voidable. And it is said that this particular gap is the reason why child marriages continue to, continue in India, in the sense, particularly in the rural areas, particularly in the semi-urban areas. What do you have to say about this?
The lacuna in the law is threefold. First, the lacuna in the law is regarding Section 3 versus Section 12. Section 3 makes the marriage voidable, which means that a child will, once she or he attains majority, as I said, they can go ahead and file for annulment of the marriage in court, which means it needs a positive action. It's not void on its own. Whereas under Section 12, a child marriage is void if the child has been kidnapped, or trafficked. So that is where the criminality comes in, which means that you have been abducted from your legal guardian, and against your guardian's consent and against your own consent, the child has been contracted into marriage.
So that is no marriage.
That is no marriage.
That is no marriage.
That is no marriage, and Section 12 is very clear about it. Section 3, because it's voidable, it becomes a slightly grey area, especially, I mean, just imagine, if a child has been married off at a tender age of 10, she has to wait 8 years at 18, where she will have the right to basically move ahead and move that petition. It can be said that, of course, a family member can also file, but majority of the times the harsh reality is that it is family members who are facilitating and solemnizing the marriage. Right. So this lacuna, voidable and void, definitely exists, and it needs to be sort of taken care of. Another aspect is that this particular act is constantly in conflict with a lot of the personal laws that agree.
There are a lot of high courts, and we've written about it multiple times as well, that, you know, there are a few high courts which are of the opinion, especially with regard to Muslim personal law, that it says that 15 years is, I mean, age of puberty, which is deemed to be at 15 years, is when, is the marriageable age for Muslims, whereas Prohibition of Child Marriage Act is 18 and 21.
Absolutely. So the Muslim personal law is that any child who has attained the age of puberty can enter into marriage, but at 15 it is presumed. You don't need evidence of hitting puberty. You're absolutely right, Apoorva. We've had very contradictory judgments in the same year. Right. In 22, we had the Fiza judgment from Delhi High Court, and then we have the Pasha judgment from Karnataka and the Rahul judgment from Karnataka. But the Fiza judgment is absolutely contrary to the precedent set by the Honorable Supreme Court of India in 2017, which is absolutely the 2017, the independent thought judgment, which says that any person who goes ahead and has an intimate relationship with his wife who is less than 18 years old, it gets covered. It is a criminal act and it will attract POCSO. POCSO is a special legislation, so it will have an overriding effect over any personal law. And as I said, that the Prohibition of Child Marriage Act, the existing act, comes into conflict with the personal law and customs many at times. And this brings me to my next point, where I think that Uniform Civil Code is very, very necessary, because it's often said, "Betiyan sabki sanjhi hoti hain." So children need to be protected. It is irrespective of which community you belong to, which religion you belong to, which caste you belong to, which creed you belong to. You are a citizen of India, there needs to be uniformity. And of course, the fact that if you're going to have one age, whether it is 18 for girls and 21 for boys, or 21 for everybody, you need to have that uniformity, and there cannot be any lacuna, any dichotomy in the law.
Bansuri, I would like you to address to this another line of criticism, which one often gets to hear, is that most of the government interventions on elimination of child marriage actually tend to address issues in the realm of either education of the girl child, or providing her with proper nutrition, or healthcare, reproductive healthcare, rather than actually focusing on prevention of child marriage or protection of the child. So how do you respond to this?
I think that is perhaps not a very fair criticism. As I said, this is a social evil. It needs to have a holistic approach. You need to have awareness campaigns like Beti Bachao, Beti Padhao. You need to actually have Sukanya Samriddhi Yojana, which takes away the economic burden on parents. See, we are a country which is also dealing with social evils such as female feticide and female infanticide. Child marriage is definitely one amongst many. And in order to actually deal with this problem, awareness is the first step. So all these government schemes, whether related to nutrition or her health or her education, they are very important, because that is when parents will stop seeing, especially in cases of girl child, seeing her as a burden.
But we've had multiple laws and still we haven't been able to stop child marriage. What is the reason? Can you say that this is the failure of the law, or is it the failure of the administration in implementing the law?
I think we are a very large country. and we are the most populated country in the world. This is a problem. It's a social evil which has perpetuated over generations. I would like to have a slightly more optimistic view. We have 3 women here. I think this would not be possible.
Another optimistic view is that most of the guests have also been women,
And within our
actually.
newsroom as
saw
well,
that.
we have a women majority newsroom.
I saw that and I'm very proud of that.
Well, so let's come to POCSO. Since you, spoke at the beginning of this show that, PCMA kind of has to be aligned with POCSO. Not in the sense it needs backing from the POCSO. But now, recently, we've had many judgments where the courts have actually kind of questioned the age of consent. As of now, the age of consent is 18 in POCSO.
Yes.
And this has been questioned particularly in the context of consensual sexual relationship amongst teenagers. And in many of these cases, these teenagers are actually facing criminal trials as if they are criminals. So at one point of time, the courts are talking about bringing down the age of consent, and then you have this bill where the government is planning to increase the age of marriage. So how do you bring harmony,
The bill is bringing the age of marriage to 21, not the age of consent. Age of consent remains at 18. Now, consent, I must say, is a very sticky wicket. You're a mother yourself.
Yes.
One day he's going to be a teenager.
Yes.
Dread the day.
No, well, one of them already is. So it's okay.
Oh, then great. So you're sweating already. Yes. See, the fact of the matter is, let's look at it in a very generic manner. Once you attain the age of 18, you're equipped to vote, so you know what is right from wrong. You can drive, which means that you have, the maturity of not banging into people and running over them. Consent needs to be 18 for the simple reason. There is a very skewed concept of modernity. There can sometimes be peer pressure. Consent, whether it is implied or it is explicit, a 16-year-old teenager who's still in school or junior college, as a lot of Mumbaikars will say, we're not in school, we're in junior college, you are still 16. You need those 2 extra years to come to terms not only with what is right, what is wrong. Are you making educated choices? And I must talk even about biological well-being. We all know that one of the reasons why these laws are in place is because your body is not developed and not biologically equipped to handle the repercussions and the consequences of intimate relationships. You need to have that maturity. I know children these days, they have access to a lot of information. But remember, we're talking about a country which is not just urban in nature. Majority of India is in the villages. You need to have a generic law, and you need to make sure that nobody misuses the consensual. If the age of consent is 16, you don't... there are so many predators in online chats. How do you protect your children? We have to protect the children. They're the future of the country. So the age of consent being 18 makes sense. And I think the central government is very categoric about it. They even placed this aspect on the Rajya Sabha.
Yeah.
The age of marriage being increased to 21, as I said, it increases job and education prospects for girls as well as boys. And also, if boys are being given that sort of time of being 21 years, then why not women? We're talking about gender equality. Raising the age of marriage to 21 will ensure that India's vision of women-led development really fructifies.
So basically, it boils down to increasing awareness.
It boils down to increasing awareness and deterrent. You need to be afraid of the law. Awareness alone doesn't cut it. You need to make sure that if you're going to try and scuttle the law, there will be some very serious punitive repercussions for it.
But then don't you see the personal laws hampering the objective of actually having, a deterrence? Because On one side, personal laws are permitting child marriages. I mean, even under the Hindu Marriage Act, of course, there is an age, 18 and 21. But all of us know that if somebody below 18 gets married, then again, it's not a void marriage. It is a voidable marriage. You have to go to the court for divorce. So in a way, indirectly, there is acceptance of child marriages. So how do we make sure that, the punitive law is actually deterrent?
First, you need to have a uniformity across the board. There needs to be one law. It's like basically imagine two children in the same household and then being governed by separate laws. It doesn't cut it. That discrepancy between laws between various communities, that needs to be done away with first. So the courts in India need to be told that this is it. So therefore I come back to UCC. We need the uniform civil code because it will codify everything, not just marriage, inheritance, divorce, everything. Once you know that this is the law of the land, no pun intended, once you know that this is the law of the land, that is when all these discrepancies can be ironed out. Today, I agree with you that there are a lot of these sort of in the garb of personal laws. Many of the provisions of the Prohibition of Child Marriage Act are scuttled. People do, and in order to make sure that this social evil does not perpetuate, we need the Uniform Civil Code.
Right, but just focusing on, if we just talk about the Prohibition of Child Marriage Act with regard to void and voidable marriages, and it's also been a while, the law came in 2006. Do you think individually the law needs a relook?
It does, and that is why one of the aspects of the 2021 bill is that they are making sure that the act has an overriding effect.
Right, that's another,
which is very important.
Because this is something that courts have also pointed out, the confusion does revolve around it not specifying that, the overriding effect.
I think, Apoorva, we need that clarity because try and understand, once you have a child contracted into marriage, there's a lot of time for brainwashing her and him. Right? And sometimes people just give up. So awareness is one aspect where you tell them what is their right, but you need to equip them with very stringent laws so that they can actually come out and speak about it and take action.
With that, we've reached the end of this episode. As I mentioned, in this episode, we spoke about the Prohibition of Child Marriage Act 2006. We spoke about how the law equips people with tools to make sure that the child marriages happening on ground are prohibited, prevented, and also that there's enough awareness around this social evil. However, of course, there's still a lot that can be done. There's still a lot that needs to be done. And one way to do that is starting conversations around it, which is what we're trying to do with this show. Hope you enjoyed the episode. Do let us know in the comments section for sure, and do follow us on social media.